So to sum things up, we now know the difference between proof and evidence. When we're referring to proof, we're really talking about the effect and result of evidence, right? It's the degree and quality of evidence, specifically aiming to produce the conviction, right? Evidence, on the other hand, is the means of proving or disproving the fact. Okay, so there's a difference. And as I said earlier, the focus of an investigator, of an environmental law enforcer that's charged with investigating a particular violation, the focus should be on evidence, not proof. Proof is the goal, it's the objective, but evidence is the way to that goal. Okay, so again, the focus should be on evidence. All right. Now, when we're talking about collection of evidence, as I said earlier, it usually involves a series of evidence, a series, of facts that lead to proof of another fact. Okay, until you're able to prove the ultimate fact. So let's differentiate now. Because these are the two aspects of evidence. There's the ultimate fact, which is what you're proposing and what you're aiming to prove. Okay, it's the ultimate proposition that you are aiming to establish. So what we're specifically referring to there are the offenses, that are committed. So, for example, when we were talking about the forestry code, we were talking about cutting, gathering, and collecting of timber without a license. So the proposition there is that a person did cut, gather, collect timber without a license. So that's the ultimate proposition. That's what you're aiming to prove. Okay. Now the supporting fact or supporting propositions really, or in this case evidence, are those that provide proof of another fact. So for example, going back to the ultimate fact, the ultimate facts that you would provide for the proposition that this person committed this act of cutting, gathering, and collecting without a permit might be that there is a witness testimony, that witness having seen this person actually cut, these trees, these timber. And then there might be a picture of stockpiled logs on his property. That would be another piece of evidence. And then maybe a certification from the DNR that there is no permit issued to this person. So those are the ultimate facts that prove that proposition, right? But the supporting facts are exactly the same, in a way the same, except the same in a sense that it's each of those specific facts that I mentioned provide the support, right? Like the witness testimony essentially prove that he did cut. Okay, it doesn't necessarily prove that he didn't have a license. It doesn't necessarily prove that he gathered, but there's proof that he actually did the cutting of timber, right? Same for the picture. It may not prove that he actually cut. What it proves is that he gathered, because there's a picture of stockpiled lumber, and it may not necessarily prove also that he has gathered without a permit, right? That's where the other fact comes into play, the fact from the DNR, some type of certification or something to the effect that says that DNR found no permit issued to this person for that, for cutting, gathering, or collecting timber. Okay, so those are the supporting facts, but taken together, okay, they do provide the ultimate fact, or at least they provide the truth to address the proposition that this person did indeed cut, gather, and collect timber without a permit. Okay, so those are just keep that in mind. There's two aspects. So in other words, when you're as an investigator, you're not just aiming for that ultimate fact. You almost, that's part of building, right? It's you're building a case, so that involves collecting bits and pieces of the puzzle, so to speak, until you complete the entire puzzle. Okay, so that's kind of how it works. All right, so let's move forward. Let's talk about who carries the burden of proving, right? When we're talking about burden, there's two burdens that we should keep in mind. The first is burden of proof. And when we're talking about burden of proof, that's really the duty of government. Okay, since these are the cases that we're talking about are criminal and administrative cases, they're violations of law, right? So it's it's the onus of government to prove that the accused actually did violate those laws, right? So the burden is on the government, more specifically on the prosecution team, which comprise the prosecutor and the investigator. It's their onus. It's their duty, rather, to establish the truth of a given proposition or issue. So, of course, the proposition is that this person cut, gathered, collected timber without a license or without a permit, right? So it's their duty. The burden is on them to prove that. Okay, so and in these types of cases, when we're talking about burden of proof, we're talking about something that isn't shifting. It's usually static. Okay, it's since this is either a criminal or administrative case, the government will generally be burdened with proving the case. Okay, so again, throughout the entire case, the burden would be on the government throughout. Okay, the burden would be on the government on proving, on establishing the truth of the given proposition. Okay, now there is also such a thing called burden of evidence, and burden of evidence is the natural or the logical necessity, rather, in response to the allegations made by the government, right? So, it starts that way anyway. So you have the government first that alleges that a violation has been committed. They provide proof, and then, of course, the defense or the accused and his defense team would respond. It's their logical necessity, okay? And it rests on them to overthrow whatever prima facie evidence was presented by prosecution to say that they did commit this offense or this violation. So they are, presented with a situation where they have to, as a necessity, they have to overthrow that. They have to present their own prima facie evidence to overthrow that. Okay, so that's burden. Now let's dig a little deeper and look at the parameters to the rules on evidence. Okay, let's start with admissibility. Okay, of evidence, and what admissibility refers to is that it refers to the question of whether or not evidence is to be allowed at all. Okay, not just considered but allowed. Okay, so in this instance or in this situation, in order for evidence to be admissible, at a very high level, there must be two requisites that has to exist. First, the evidence must be relevant. Okay, it must have such a relation to the fact as to induce belief in its existence or non-existence. Siguro the easiest way to make sense of what constitutes relevant or not is, if it's kung may connect, right? Just using a common slang or a common thing that we use these days in the Philippines, yung kung may connect ang sinasabi, right? So if, for example, your girlfriend says or accuses you of being babaero, ng bababae, and you all of a sudden in your defense said you went to National Bookstore. Okay, so anong connect nun, di ba? So parang hindi relevant, it's not addressing the accusation directly. It's not giving any evidence that would contradict the allegation. So it's not relevant. Hindi walang connect. So if it was evidence presented in a legal proceeding, that question would come up as to whether it's relevant or not. Okay, kasi walang connect eh. So it would probably not meet the that first requisite of whether it's relevant or not. Okay, so again, when we say relevant, kailangan may connect. All right. The second requisite is that it has to be competent. And when we say competent, we're not referring to intelligence quotient. We're not referring to IQ. And we're not saying is it smart or is it dumb in that sense. When we say competence, we're really talking about whether it's legal or not. In other words, the evidence must neither be excluded by law nor by the rules. So in other words, kailangan hindi siya, it doesn't necessarily have to be in the law or the rules. It just has to not be excluded, okay, by the rules. All right. So if you might remember earlier, I talked about the one support. Okay. I remember I mentioned there that I was able to prove with certainty na support nga talaga siya, right? But I raised the question of whether my evidence to prove that is admissible or not. So this is what we're getting into right now is to try and answer that with more specificity. Okay, kasi kanina I just said that it looks like I violated a number of laws in obtaining that evidence. So the question is, is it admissible? All right. So, and that's when I first introduced the concept, if you don't already know what the concept is, but the concept of fruit of the poisonous tree, right? So that being said, let's dive right in to what constitutes fruit of the poisonous tree. We're going to now talk about a section within the rules that is being referred to as exclusionary rules. Okay, so these are the instances in a number of sources, Constitution, the law, and so forth, where there's specific mention or specific rules that says this is how this evidence is to be acquired, right? That if it's done any other way, then it would not be admissible. Okay, so that's what exclusionary rules refer to, and again, using that figure of speech, the fruit of the poisonous tree. Okay, so let's look at the instances where there are inadmissible evidence as a result of these rules. So let's start with what we can find in the Constitution. All right, the Constitution, under the Bill of Rights, there's a number of things there. Well, the Bill of Rights, as I'm sure you are aware, are a bundle of rights that the state guarantees to every citizen. It guarantees against state intrusion. So, when it's talking about unreasonable searches and seizure, it's referring to itself. The state is referring it to itself, saying, I, as the state, guarantee you, citizen, that I'm not going to do any unreasonable searches and seizure. Okay, so that's what it's referring to there. So anyway, there are a number of provisions under the Bill of Rights where we find instances where certain evidence might be excluded. All right, so I've started with the first one, the unreasonable searches and seizure. So if, for example, evidence is acquired without a warrant, okay? Evidence is acquired without a warrant, no search warrant, that would be excluded, okay? If it's a search that, given the circumstance, must be with a warrant, okay? Then it would be considered an unreasonable search and seizure, okay? So an unreasonable search to acquire evidence, and that such evidence is seized, and there are no warrants to allow that, and then that would therefore be considered an unreasonable search and seizure. And that, of course, if it's done by an agent of the state, by the government or an agent of the government. So a law enforcer is obviously an agent of the government. Okay, you, if and when you become an environmental law enforcer, would also be an agent. So any search or seizure that you would do without a warrant would be considered unreasonable search and seizure, and therefore whatever you collect would not be admissible. Okay. Now, there are instances where evidence could be collected or even people arrested without a warrant. So there are rules that provide, actually it's under the rules of court. There are instances where that is allowed, and for as long as those rules are followed, the evidence collected under unwarranted search would be allowed. But if it is not done following those rules, then it would be inadmissible. Okay. Privacy of communication. Let me defer that until we get to the next rule because it's one and the same. But anyway, I'll talk about that then. Rights of the accused under custodial investigation. Okay, so the Bill of Rights guarantees that if you are invited to the police station for questioning, which is referred to as custodial investigation. Okay, anytime you're within the custody of law enforcement authorities and you are made to answer questions, then you are or could be under custodial investigation. It could be a simple, in fact, there's jurisprudence that made it so even a simple invitation, okay, to the police station, even without a warrant, if the fact that you're there and you're being asked questions, you are essentially guaranteed rights under the Bill of Rights, okay, such that if testimony is acquired from you in violation of these rights, such evidence would be inadmissible. Okay, so an example of evidence that might be acquired from you in violation of these constitutional rights under rights of the accused under custodial investigation is probably the most obvious is if you are asked questions without a counsel. Okay, you have the right to counsel because that's guaranteed by the Constitution. But let's say they would not allow you to get a counsel and they asked you question, they forced it out of you, then whatever you say shall not be used, cannot be used. It will be excluded. It'll be inadmissible. Okay. Same if you were tortured. If evidence was acquired from you because they tortured you, they forced you, they imposed violence on you, they threatened you, intimidated you, okay, or in any way, force it out of you without your free will. It's not your free will. You didn't voluntarily give it. Okay, then that would be inadmissible. Okay, so all right, so that gives you an idea of fruits of the poisonous tree out of violations of constitutional rights. Okay, there's also statutory rule, or at least exclusionary, or at least instances where evidence will be excluded based on laws. There's two examples cited here. The first one, not so much probably in environmental cases, but I thought I'd share it because it speaks to it being curable. Okay, lack of documentary stamp. So this one is referring. This is under the it's a taxation law. It's under the National Internal Revenue Code. Okay, it really says what it says basically is that for evidence where such evidence must have a documentary stamp. Okay, for as long as it doesn't have that documentary stamp, it cannot be used as evidence. It's inadmissible. Okay, it's curable though. Well, when you, as the person who wants to present that as a evidence, and it's your document. Okay, if you get the documentary stamp, then it becomes admissible. So it's curable in that sense. Okay. Now the second example is also referring back to one of the constitutional provisions that I mentioned, the right to privacy of communication. Okay. So this one refers to the anti-wiretapping law, RA 4200. It's a very old law, which makes it so any private communication that you would have, if for some reason the state, maybe through a law enforcer or any agent of the state, any agent of the government, taps your phone, where you're having your private communication, or in any way intercepts your private communication, okay, whatever they're able to acquire, okay, would be inadmissible. Okay, the constitutional guarantee just makes it so the state is guaranteeing that they won't violate your private communication. RA 4200 goes one step further and criminalizes it. Okay, so when a law enforcer does violate this law, not only is the evidence that they collect inadmissible, but they would also be criminally liable. So that's the difference. All right. What else? Okay, Rule 130. Rule 130 under the Rules of Court. This is the rules on evidence. Okay, so there's a number there where evidence that does not comply with those rules would be considered inadmissible. I won't go through each one of them, but there's one in particular that I want to just briefly talk about, and that's the hearsay evidence rule. Okay, and hearsay, as I'm sure you already know, is chismis, chismax, things you hear on the grapevine, ika nga nila. Okay, and it's second-hand news. It's something that you yourself did not personally hear. You have no personal knowledge, but somebody just told you. Okay, so that information, if you were the witness, you were the one that was told that. Okay, that evidence would be inadmissible because it's in violation of this hearsay evidence. Okay, so in other words, as written here, a witness can only testify to those facts which he knows of his personal knowledge. Okay, and essentially it qualifies that is which are derived from his own perception. So he had to actually have been there himself. Okay, and he saw it firsthand. It's not secondhand. Okay, there are exceptions, but we won't go through them. But just quickly, just so you know, a dying declaration would be one. Where you have somebody, let's say for example, who got shot and he's dying, and you're able, you come over to him, and he tells you who shot him. Okay, so if you were to testify to that fact, that would in essence be secondhand news, but it could be allowed under hearsay evidence. Okay, under what they refer to as the dying declaration. So it's one of the exceptions. Okay, so let's move forward. What else are there? Court issuances. Here are some examples. So rules on electronic evidence and rules on cybercrime warrants are too far apart, since they talk about either electronic evidence or computer data, which are synonymous. Okay, the rules on electronic evidence stems from the E-commerce Act from some years ago. I think it was sometime in the 1990s. Okay, and the rules on cybercrime warrants hinges off of the Cybercrime Prevention Act, which is a fairly recent law. Okay, so there are some rules there on the rules on electronic evidence. For example, it's talking about compliance with authentication. That's you're proving essentially that a particular piece of electronic evidence is exactly the evidence that was collected, so it's authentic. So there's some rules on how we provide that authentication. Rules on cybercrime warrants does the same thing, but goes further. There's a number of rules that it covers. One particular mention is as to the people that are authorized to obtain those warrants. Okay, kasi hindi lahat ng law enforcers, whether PNP or NBI, not all of them technically are, at least according to this rule, not all of them are allowed to get these cybercrime warrants. There's a definition provided in the law itself, the Cybercrime Prevention Act, as to who the law enforcement authorities are. It refers to the PNP Anti-Cybercrime Group and the NBI Cybercrime Division as the two entities who are considered law enforcement authorities. Okay, and so whenever the law refers to law enforcement authorities, including the rules on cybercrime warrants, where it's referring to who can apply for these warrants, who can obtain these warrants, it's referring to law enforcement authorities. So meaning it's only those two sections of those two law enforcement agencies. Okay, there's some questions there that kind of put doubt on whether they're really the only one. But right now, for us, as far as the courts are concerned, only those two sections are allowed. So, if, for example, a warrant was obtained by another section of the PNP, there's a question of whether that would be admissible evidence or not. Okay, so since there hasn't been any question yet, no test, nothing has yet come up to the Supreme Court, except for when the law first came into effect, it was challenged. But that was the only time that it went up to the Supreme Court. Actual cases to test some of these provisions have not made it to the Supreme Court. So, in any case, for now, whatever the rule says, those must really be followed. Okay. Child witness rule. Okay, so that refers to instances involving child witnesses because of their tender age. There are particular rules that must be followed in order to get their testimony. Any violation of that would make such testimony be inadmissible. Judicial affidavit rule, that is a relatively new rule that provides that testimony of a witness that would form part of a direct examination could be reduced into writing. So instead of inviting that witness for a direct examination, they could actually just do it in paper, where a lawyer would ask the witness some questions, and all of that would be in writing, and then it would be it would be a sworn testimony. So that, in other words, the witness would be sworn in, and basically that judicial affidavit, being that it's sworn in, it makes it a judicial affidavit, would replace the direct examination. Okay, so anyway, those are just examples of rules that make it so if they're not followed, evidence collected therefrom would be inadmissible. Okay, so going back to one support, if I could just go back to that real quickly. Remember, when I described the situation, I was able to obtain, actual proof that he is support, right? The question, of course, is, because it appears as if I violated two laws. Basically, I may be in violation of the anti-voyeurism law, and of course the revised penal code for having trespassed his house. Now, where do you think, based on some of these sources that I cited, where do you think that would fall? Because I think, as I'm sure you're already gathering, that would clearly be the evidence that I collected would be fruit of the poisonous tree. Okay, would therefore be inadmissible. But where would it fall in your mind? Okay, and just to make it easier, basically make it easier for you, it's really under the constitutional provision, the unreasonable searches and seizure, because again, I came in there with an intent to search for evidence and seize evidence, which I did. And I had to break laws to do that. But the point is, I didn't have the authority to do that search and seizure. I didn't have a warrant. And it wasn't. We didn't go over the specifics, but it clearly wasn't. You'll just have to take my word for it. It clearly wasn't one of those authorized cases of warrantless searches. Okay, so being that that's the case, the means by way it became a fruit of the poisonous tree is because it was an unreasonable search and seizure. Okay. Now, besides admissibility, another important consideration in case buildup is the weight of evidence, specifically what they refer to as the probative value. And when we're talking about probative value, we're really referring to the question of whether or not the evidence proves an issue. Okay, so just to differentiate between admissibility and probative value, when we're talking about admissibility, we're saying that it's only admissible if it's relevant and competent, right? So it depends on relevance and competence of evidence. Probative value, on the other hand, talks about its tendency to convince and persuade. All right, so they're two different things, and thus are important considerations when you're building a case. So just to give us a better understanding of probative value, let's illustrate, okay? Let's bring back that hypothetical case I raised earlier, where you have a person, let's say his name is Juan de la Cruz, right? He was accused of violating the forestry code, specifically section 68. So let's pull that up real quickly. Section 68 of the forestry code, okay? So section 68 refers to cutting, gathering, and or collecting timber or other products without license. Specifically, the act is cut, any person who shall cut, gather, collect, or remove timber or other forest products from any forest land or timber from alienable and disposable public lands or from private lands without any authority under a license agreement, lease, etc., etc. Okay, so that's the offense. Now, in scenario one, well, I'll bring up two scenarios so we can differentiate and we can best see how probative value plays in. All right, on scenario one, okay, here it is. So in addition to certification from DNR that there is no permit and that Juan de la Cruz does not have a permit to cut, gather, or collect timber. Okay, he has no permit to do that, right? So in addition to that, the certification from DNR that he does not have a permit, okay, a witness through a sworn affidavit indicates that he actually saw Juan de la Cruz in the act of cutting down timber. All right. So based on those two pieces of evidence, we can sort of conclude, we can conclude that there appears to be a violation according to this offense, right? The elements do coincide, right? Because there is no permit, okay, that's the qualifier, right? And the act here was cutting timber without a permit. And the proof of Juan de la Cruz cutting down timber is a witness testimony who actually saw firsthand Juan de la Cruz in the act of cutting down timber. So the affidavit, the sworn affidavit of that witness does have probative value, right? Because it's evidence that proves an issue. The issue here is whether he cut or not, right? And the testimony, through a sworn affidavit, does indicate that that witness saw firsthand, so this person has personal knowledge of one actually cutting down a timber. So it has probative value. Now, let's pull up another scenario, okay? And this also refers back to that same scenario I said earlier, right? I gave you three scenarios earlier. One was there's a testimony from a witness that saw the accused in the act of cutting, and then the second scenario was that there was a picture taken of timber that are stockpiled in the property of the accused. And then the third scenario was again the fact that there was no permit, right? So let's pull up the second scenario, okay? But instead of a picture, okay, we'll say it's a picture. So basically, so in addition to the certification that there is no permit, Juan de la Cruz does not have a permit to cut, gather, or collect timber, okay? And in addition to that certification from DNR, there was a picture that was entered into evidence that shows timber in the property of Juan de la Cruz, okay? A picture showing timber in the property of Juan de la Cruz. Now, let's think for a minute about probative value. We said probative value refers to the question of whether or not the evidence proves an issue, okay? So the issue is whether or not Juan de la Cruz gathered timber, without a permit, right? The without the permit part we already know. That's proven from the certification. But how about the gathering? Okay, the act here is gathering, so there is kind of a positive act of actually gathering, right? But the evidence that we have really is just a picture of timber that's stockpiled in Juan de la Cruz property. So does that prove an issue? Does that prove that Juan de la Cruz actually gathered? Okay. Yeah, I guess just to a certain extent, right? But it's not conclusive. It's not enough, right? So in other words, it doesn't carry the weight that you want it to carry. It doesn't prove the issue. The issue being that whether Juan de la Cruz actually gathered without a permit, actually gathered timber without a permit. So there you have it. You can sort of differentiate between the two. The first one is a little bit more conclusive, okay, because there was an actual, witness who saw firsthand Juan de la Cruz in the act of cutting down timber. Whereas in the second scenario, there was no actual witnessing of Juan de la Cruz gathering timber without a permit. Okay, all there is a picture showing that there is in Juan de la Cruz property a stockpile of timber, and even that is uncertain as to whether that's timber that was taken from public lands and so on and so forth, right? So it's not completely conclusive. So the probative value is not quite where it needs to be, right? The weight is not quite there. It doesn't prove conclusively the issue, right? It may help prove the issue, but it's by itself doesn't prove an issue. It needs to be more. So in other words, the probative value isn't quite there. So you can see the difference, okay? Proceeding now to the forms of evidence. The rules on evidence provide three forms, and we'll discuss them one at a time. All right, let's start with the first one, which is real or object evidence. Real or object evidence are essentially not a replica or mere representations of something or a reconstruction of past events as narrated by a witness. What they are the real thing themselves, okay? The real things, okay? The real thing that is addressed to the senses of the court. These are the actual tangible objects that can be felt, that can be touched, okay? That can be seen, all right? And insofar as their requisites for admissibility, we did say earlier that evidence needs to be relevant and competent, and that is precisely the case here. Okay, that they must be relevant and competent, but there are additional requirements that need to play in. The first, in addition to the relevance and competence, is that the evidence, the object itself, needs to be authenticated by a competent witness. So what that is referring to is a testimonial sponsor, somebody that can pretty much testify that that is the object, the object to be the actual thing involved in the litigation. Okay, so their testimony aims to identify the object and to also say, in identifying it, that it is the actual thing that's involved in the litigation. Okay, so that's a second requisite for admissibility, that it must be authenticated by a competent person. A third requisite is that it must be duly marked and formally offered. Formally offered really is the work of the prosecutors. That's when they introduce the evidence in court. So as an investigator, a environmental law enforcer, the investigator assigned to the case, you would probably not participate in that. But you do play a big role in the marking. Okay, they're duly marked. When it says duly marked, that's something that you as an investigator, the same person that would go out and find those pieces of evidence and collect them, okay, then you have that responsibility of marking them, purposed on preservation okay, to ensure the integrity of that evidence. Okay, so if you collect an object as evidence, an object evidence, you would, at the scene where you collected it, you would mark it so that that marking stays on that object throughout the proceedings, so it can be identified to be the same object that you collected and the same object that's being presented at that point in time at the hearing. Okay, so there you have it. Now let's move forward. What other forms of evidence are there? Well, besides the real and object evidence, there is one that is very much like an object evidence, and that's documentary evidence. Okay, except there's a slight difference here, or a big difference really. They're both tangible things. Okay, but in documentary evidence, it's not the document itself. It's not the document itself that is the evidence. It's really the contents of. Okay, so if we'll quickly read it, it says it refers to writings and any material containing modes of written expressions offered as proof of their contents. It further goes in saying any object or material having any matter expressed or described upon it by marks capable of being read. So again, it is the content of the document, such that the document would mean it doesn't necessarily need to be a piece of paper. It could be any object, so long as it's not the object that's being presented, but the content that is on that object, the writings, the markings, the expressions, right? So it could be a desk. So if there's, say for example, the desk has some markings on it, and it's being considered a documentary evidence because, it's what's on those markings. That's the evidence that's needed to be presented. Okay, so another good example of a non-paper documentary evidence would be walls. When you have graffiti, right? Maybe graffiti that's libelous, defamatory, or maybe even subversive. Anything that could be considered evidence for whatever hearing. In those cases, it wouldn't be the wall itself, but the actual writing on that wall that would present as the documentary evidence. Okay. One quick thing, I want to just quickly go back to the object evidence. I mentioned that in object evidence, it's a thing that you can touch and feel. It's also important to know, because I mentioned the graffiti on the wall, that object evidence isn't necessarily something that could only be brought to the court. It could actually be something that cannot be brought to the court, and so in which case there would be a need to do an ocular, right? So maybe a piece of land somewhere, the neighborhood, or if that in itself is the object evidence, then the court can actually make provisions to go out there. It could also be things in like the wounds of a witness, somebody that was wounded in the criminal case, and so there's a need to show that this person was wounded. An ocular in that sense, right? Okay, so now going back to the documentary evidence. All right. So again, the contents is the object. It's not the object itself, but the content that is the object of evidence. All right. An important point of mention here. Earlier, we were talking about electronic evidence as well as digital evidence that are under the rules on cybercrime warrants, and then the earlier rule also on electronic evidence. It's important to note that digital evidence or electronic evidence is under those rules. They are deemed to be documentary evidence. Okay, so as documentary evidence, let me go to the requisites here, because the requisites for documentary evidence are identical to that of the object evidence. So what's critical to note here is the marking, right? The necessity to mark, the requisite to mark that evidence. So if it's a physical thing that you can touch, right? Even if it's a document, right? that is that's something that you can mark easily, right? But if it's something virtual like electronic evidence, digital evidence, where you can't really mark it, maybe you may be able to mark the flash drive where it is stored, the flash drive or an external drive, but not the actual data itself, okay? And there's a need to actually mark the data itself, at least identify it, because especially when it comes to digital evidence, they're very volatile, okay, and in many cases they're ephemeral and they change. You just access it and it changes the characteristics or the qualities, okay? So there's a need to preserve it such that it is not susceptible to change, because when it changes, it's essentially contaminated. You wouldn't be able to use it as evidence because it would be no good anymore. It would be contaminated. So in cases like that, there's a special process involved. First, in the means of collecting that evidence, the digital evidence, an investigator, perhaps like yourself, when you do become one, you would be doing a process called imaging, where you would go to a device where that digital evidence is stored. Okay, you would image that digital evidence. It could be a folder, it could be just one file, it could be the entire hard drive of that device, right? And when you collect it, you would be doing, as I said, this process called imaging. And this process of imaging, what it does is it takes an exact replica of whatever that data is that you're collecting as evidence. Again, it could be just one file, it could be a folder, or the entire hard drive, okay? Whichever it might be, the imaging process would make a replica of that, keeping all of its qualities, all of its characteristics, okay? And when it does that imaging, when it makes that replica, it produces the digital DNA called hash value, okay? And that's your basis for saying that that's authentic, because if, when you collected it and you record that hash value, okay, and that hash value remains the same for when some months, some years later, and that evidence is presented in court, and it's hash value checked, okay? If that hash value is different from the hash value that collected, when you collected it, then it's no longer usable. It would be considered contaminated evidence. But if it's the same, then it's authentic, okay? So that's kind of the process in general on digital evidence. What makes it even more complicated, especially now that we are in a global world, and everything is globalized, meaning everything is within reach. It doesn't have to be something within the Philippines, especially since we use social media systems, platforms that are based in the US. So what about in cases like that where the evidence is on Facebook, for example, or Twitter, and those pieces of evidence are on servers? They're not on the computers here in the Philippines, but they're on servers. They're on Twitter server, they're on Facebook servers, and those servers are in the United States. How do you access that? Okay. Now there are some techniques that you could do. There's some techniques, in fact, that that are being practiced now. But generally, the right way to get authentic evidence would be to request it directly from those service providers. Okay. Now that gets a little tricky, because you couldn't. You could request up to a certain extent, but when you're talking about the actual authenticated data, you would actually need to go through the government, the United States government, to do that. Okay, and that's usually facilitated through what's called a mutual legal assistance treaty. Okay, and fortunately, the Philippines and the U.S. have such a treaty, and the mutual legal assistance treaty, as the name suggests, is a treaty that enables both states to assist each other, especially when it comes to evidence. So this is precisely one example of how that assistance can be made. Since the evidence is in the U.S., here in the Philippines, the investigators, or in some cases the prosecutors, would go through the proper channels to the Philippine DOJ to request to do an MLAT request, a mutual legal assistance treaty request, where that request is then, it's started by the Philippine DOJ, then it's sent to the U.S. Embassy, to the United States Department of Justice office, who then, reconciles it with the treaty to make sure that it is consistent with the agreement, with the treaty, and then proceeds to submit it to some law enforcement authorities in the United States, FBI perhaps, excuse me, and there would be a subpoena that would be delivered to Facebook or Twitter, wherever the data is, excuse me, and of course the digital evidence would be requested from them, and when Twitter or Facebook complies, then there is some authentication process that involves certification by the U.S. government, such that when you receive it back in the Philippines, you already have the necessary authentication. Okay, that would make it admissible in the court, in Philippine courts, because it'll show that the U.S. government, through the treaty, was able to acquire legally the authentic evidence that you're looking for. Okay, so that's kind of how it works. It gets a little complicated, but there is a means to do that. Okay, and there is also a necessity, actually it's a feature, that before you even do that, because it's evidence on the internet, especially on social media, is volatile. If somebody posts something, a comment that is libelous, something that is criminal, okay, that person could easily delete it, in short order, right? In a few minutes, a few seconds after he posted. Okay. Fortunately, because of technology, there's a way to have that preserved, while you're waiting to have that mutual legal assistance treaty request process. So anyway, there's a process to do that. Okay. So going back to the requisites for admissibility, as I said, as long as you're able to get it authenticated, and for electronic evidence and digital evidence, there is a special process, even if they're deemed as documentary evidence. The process is a little different, and those processes have to be followed, because, as we said earlier when we were talking about exclusionary rules, if the process to obtain that evidence does not follow the rules, then they would be excluded. They would not be admissible evidence. Okay, so there you have it. Just some important notes for you to know as an investigator. Okay, so the third and last form of evidence that we're going to talk about is testimonial evidence. And testimonial evidence is essentially what excuse me. Okay, testimonial evidence is essentially what the witness would be telling the court, okay, based on their personal knowledge of facts and circumstances related to the case. It's elicited from them, which of course means that they're being asked questions, and then they would be responding based on their personal knowledge. Okay, so the only requirement for a witness to testify is that he is qualified to take the stand and testify. And to qualify, it's really not that complicated. It really only requires that the witness is able to perceive, okay, and that in perceiving, he or she can make his perception known. It's that simple, okay? He need only be able to perceive, and in perceiving, he can make his perception known, okay? So simple as that. Additionally, he must take an oath or affirmation. So that's basically where you when he goes up in the stand, and then you have him raise his right hand, and you ask, do you swear to tell the truth, nothing but the truth, so help you God? Okay, that's he must take that, right? And lastly, and this relates back to the first qualification, which is that he must not possess the disqualifications imposed by law. And the law, namely the rules on evidence, identify or enumerates three instances where a person would be disqualified to be a witness. Let's quickly take a look at them. Okay. So persons disqualified to be a witness by reason of mental incapacity or immaturity, by reason of marriage. Okay, there's such a thing called marital privilege, which says that you cannot testify against your spouse. Okay, such testimony would be inadmissible. Okay, and then by reason of death or insanity of the adverse party, naturally. Okay, if he dies, then there would be no need, really, if you think about it. All right. So an important point of mention here is differentiating between qualified witnesses from credible witnesses. Okay. Qualification, to be a qualified, that's an essential requirement. Okay, an essential qualification. A person must be a qualified witness before he could be a witness to a case, right? But to be a witness that is not credible, they could still be qualified, but they may not be credible. Okay, but when we're talking about credibility, it's not a question of whether they're qualified or not, but rather it really just points back to the weight or probative value of what they're going to testify about, right? So if they're not credible, perhaps they have a history of lying, right? And the opposing counsel is able to prove that, then the weight of their testimony may not be as great as it should be. Okay, but if the person is the witness is of great credibility, he's trustworthy, a God-fearing man, law-abiding citizen, all that good stuff, right? Then the weight of his testimony might provide. In other words, there is probative value. Okay, so again, credibility doesn't really refer back to whether a person is qualified or not, but more so it just talks about whether there is probative value to his testimony. Okay? The rules on evidence provide three forms, and we'll discuss them one at a time. All right, let's start with the first one, which is real or object evidence. Real or object evidence are essentially not a replica or mere representations of something or a reconstruction of past events as narrated by a witness. What they are the real thing themselves, okay? The real things, okay? The real thing that is addressed to the senses of the court. These are the actual tangible objects that can be felt, that can be touched, okay? That can be seen, all right? And insofar as their requisites for admissibility, we did say earlier that evidence needs to be relevant and competent, and that is precisely the case here. Okay, that they must be relevant and competent, but there are additional requirements that need to play in. The first, in addition to the relevance and competence, is that the evidence, the object itself, needs to be authenticated by a competent witness. So what that is referring to is a testimonial sponsor, somebody that can pretty much testify that that is the object, the object to be the actual thing involved in the litigation. Okay, so their testimony aims to identify the object and to also say, in identifying it, that it is the actual thing that's involved in the litigation. Okay, so that's a second requisite for admissibility, that it must be authenticated by a competent person. A third requisite is that it must be duly marked and formally offered. Formally offered really is the work of the prosecutors. That's when they introduce the evidence in court. So as an investigator, a environmental law enforcer, the investigator assigned to the case, you would probably not participate in that. But you do play a big role in the marking, okay, the duly marked. When it says duly marked, that's something that you as an investigator, the same person that would go out and find those pieces of evidence and collect them, okay, then you have that responsibility of marking them, purposed on preservation, okay, to ensure the integrity of that evidence, okay. So if you collect an object as evidence, an object evidence, you would, at the scene where you collected it, you would mark it so that that marking stays on that object throughout the proceedings, so it can be identified to be the same object that you collected and the same object that's being presented at that point in time at the hearing, okay. So there you have it. Now let's move forward. What other forms of evidence are there? Well, besides the real and object evidence, there is one that is very much like an object evidence, and that's documentary evidence, okay. Except there's a slight difference here, or a big difference really. They're both tangible things, okay. But in documentary evidence, it's not the document itself. It's not the document itself that is the evidence. It's really the contents of. Okay, so if we'll quickly read it, it says it refers to writings and any material containing modes of written expressions offered as proof of their contents. It further goes in saying any object or material having any matter expressed or described upon it by marks capable of being read. So again, it is the content of the document, such that the document would mean it doesn't necessarily need to be a piece of paper. It could be any object, so long as it's not the object that's being presented, but the content that is on that object, the writings, the markings, the expressions, right? So it could be a desk. So if there's, say for example, the desk has some markings on it, and it's being considered a documentary evidence because, it's what's on those markings. That's the evidence that's needed to be presented. Okay. So another good example of a non-paper documentary evidence would be walls. When you have graffiti, right? Maybe graffiti that's libelous, defamatory, or maybe even subversive. Anything that could be considered evidence for whatever hearing. In those cases, it wouldn't be the wall itself, but the actual writing on that wall that would present as the documentary evidence. Okay. One quick thing, I want to just quickly go back to the object evidence. I mentioned that in object evidence, it's a thing that you can touch and feel. It's also important to know, because I mentioned the graffiti on the wall, that object evidence isn't necessarily something that could only be brought to the court. It could actually be something that cannot be brought to the court, and so in which case there would be a need to do an ocular, right? So maybe a piece of land somewhere, the neighborhood, or if that in itself is the object evidence, then the court can actually make provisions to go out there. It could also be things in like the wounds of a witness, somebody that was wounded in the criminal case, and so there's a need to show that this person was wounded. An ocular in that sense, right? Okay, so now going back to the documentary evidence. All right. So again, the contents is the object. It's not the object itself, but the content that is the object of evidence. All right. An important point of mention here. Earlier, we were talking about electronic evidence as well as digital evidence that are under the rules on cybercrime warrants, and then the earlier rule also on electronic evidence. It's important to note that digital evidence or electronic evidence is under those rules. They are deemed to be documentary evidence. Okay, So as documentary evidence, let me go to the requisites here, because the requisites for documentary evidence are identical to that of the object evidence. What's critical to note here is the marking, right? The necessity to mark, the requisite to mark that evidence. So if it's a physical thing that you can touch, right? Even if it's a document, right? That is that's something that you can mark easily, right? But if it's something virtual, like electronic evidence, digital evidence, where you can't really mark it, maybe you may be able to mark the flash drive where it is stored, the flash drive or an external drive, but not the actual data itself, okay? And there's a need to actually mark the data itself, at least identify it, because especially when it comes to digital evidence, they're very volatile, okay, and in many cases they're ephemeral and they change. You just access it and it changes the characteristics or the qualities, okay. So there's a need to preserve it such that it is not susceptible to change, because when it changes, it's essentially contaminated. You wouldn't be able to use it as evidence because it would be no good anymore. It would be contaminated. So in cases like that, there's a special process involved. First, in the means of collecting that evidence, the digital evidence, an investigator, perhaps like yourself, when you do become one, you would be doing a process called imaging, where you would go to a device where that digital evidence is stored. Okay, you would image that digital evidence. It could be a folder, it could be just one file, it could be the entire hard drive of that device, right? And when you collect it, you would be doing, as I said, this process called imaging. And this process of imaging, what it does is it takes an exact replica of whatever that data is that you're collecting as evidence. Again, it could be just one file, it could be a folder, or the entire hard drive, okay? Whichever it might be, the imaging process would make a replica of that, keeping all of its qualities, all of its characteristics, okay? And when it does that imaging, when it makes that replica, it produces the digital DNA called hash value, okay? And that's your basis for saying that that's authentic, because if, when you collected it and you record that hash value, okay, and that hash value remains the same for when some months, some years later, and that evidence is presented in court, and it's hash value checked, okay, if that hash value is different from the hash value that collected when you collected it, then it's no longer usable. It would be considered contaminated evidence. But if it's the same, then it's authentic, okay. So that's kind of the process in general on digital evidence. What makes it even more complicated, especially now that we are in a global world, and everything is globalized, meaning everything is within reach. It doesn't have to be something within the Philippines, especially since we use social media systems, platforms that are based in the US. So what about in cases like that where the evidence is on Facebook, for example, or Twitter, and those pieces of evidence are on servers? They're not on the computers here in the Philippines, but they're on servers. They're on Twitter server, they're on Facebook servers, and those servers are in the United States. How do you access that? Okay. Now there are some techniques that you could do. There's some techniques, in fact, that that are being practiced now. But generally, the right way to get authentic evidence would be to request it directly from those service providers. Okay. Now that gets a little tricky, because you couldn't. You could request up to a certain extent, but when you're talking about the actual authenticated data, you would actually need to go through the government, the United States government, to do that. Okay, and that's usually facilitated through what's called a mutual legal assistance treaty. Okay, and fortunately, the Philippines and the U.S. have such a treaty, and the mutual legal assistance treaty, as the name suggests, is a treaty that enables both states to assist each other, especially when it comes to evidence. So this is precisely one example of how that assistance can be made. Since the evidence is in the U.S., here in the Philippines, the investigators, or in some cases the prosecutors, would go through the proper channels through the Philippine DOJ to request, to do an MLAT request, a mutual legal assistance treaty request, where that request is then, it's started by the Philippine DOJ, then it's sent to the U.S. Embassy, to the United States Department of Justice office, who then reconciles it with the treaty to make sure that it is consistent with the agreement, with the treaty, and then proceeds to submit it to some law enforcement authorities in the United States, FBI perhaps, excuse me, and there would be a subpoena that would be delivered to Facebook or Twitter, wherever the data is, excuse me, and of course the digital evidence would be requested from them, and when Twitter or Facebook complies, then there is some authentication process that involves certification by the U.S. government, such that when you receive it back in the Philippines, you already have the necessary authentication. Okay, that would make it admissible in the court, in Philippine courts, because it'll show that the U.S. government, through the treaty, was able to acquire legally the authentic evidence that you're looking for. Okay, so that's kind of how it works. It gets a little complicated, but there is a means to do that. Okay, and there is also a necessity, actually it's a feature, that before you even do that, because it's evidence on the internet, especially on social media, is volatile. If somebody posts something, a comment that is libelous, something that is criminal, okay, that person could easily delete it, in short order, right? In a few minutes, a few seconds after he posted. Okay. Fortunately, because of technology, there's a way to have that preserved, while you're waiting to have that mutual legal assistance treaty request process. So anyway, there's a process to do that. Okay. So going back to the requisites for admissibility, as I said, as long as you're able to get it authenticated, and for electronic evidence and digital evidence, there is a special process, even if they're deemed as documentary evidence. The process is a little different, and those processes have to be followed because, as we said earlier, when we were talking about exclusionary rules, if the process to obtain that evidence does not follow the rules, then they would be excluded. They would not be admissible evidence. Okay, so there you have it. Just some important notes for you to know as an investigator. Okay, so the third and last form of evidence that we're going to talk about is testimonial evidence. And testimonial evidence is essentially what excuse me. Okay, testimonial evidence is essentially what the witness would be telling the court, okay, based on their personal knowledge of facts and circumstances related to the case. It's elicited from them, which of course means that they're being asked questions, and then they would be responding based on their personal knowledge. Okay, so the only requirement for a witness to testify is that he is qualified to take the stand and testify. And to qualify, it's really not that complicated. It really only requires that the witness is able to perceive, okay, and that in perceiving, he or she can make his perception known. It's that simple, okay? He need only be able to perceive, and in perceiving, he can make his perception known, okay? So simple as that. Additionally, he must take an oath or affirmation. So that's basically where you when he goes up in the stand, and then you have him raise his right hand, and you ask, do you swear to tell the truth, nothing but the truth, so help you God? Okay, that's he must take that, right? And lastly, and this relates back to the first qualification, which is that he must not possess the disqualifications imposed by law. And the law, namely the rules on evidence, enumerates 3 instances where a person would be disqualified to be a witness. Let's quickly take a look at them. Okay. So persons disqualified to be witness by reason of mental incapacity or immaturity, by reason of marriage. Okay, there's such a thing called marital privilege, which says that you cannot testify against your spouse. Okay, such testimony would be inadmissible. Okay, and then by reason of death or insanity of the adverse party, naturally. Okay, if he dies, then there would be no need, really, if you think about it. All right. So an important point of mention here is differentiating between qualified witnesses from credible witnesses. Okay. Qualification, to be a qualified, that's an essential requirement. Okay, an essential qualification. A person must be a qualified witness before he could be a witness to a case, right? But to be a witness that is not credible, they could still be qualified, but they may not be credible. Okay, but when we're talking about credibility, it's not a question of whether they're qualified or not, but rather it really just points back to the weight or probative value of what they're going to testify about, right? So if they're not credible, perhaps they have a history of lying, right? And the opposing counsel is able to prove that, then the weight of their testimony may not be as great as it should be. Okay, but if the person is the witness is of great credibility, he's trustworthy, a God-fearing man, law-abiding citizen, all that good stuff, right? Then the weight of his testimony might provide. In other words, there is probative value. Okay, so again, credibility doesn't really refer back to whether a person is qualified or not, but more so it just talks about whether there is probative value to his testimony. Okay. So it looks like I've covered all the things that I wanted to cover under fundamentals of evidence. So, and we did cover quite a lot, as I'm sure you'll remember. It took us a little bit of time. So at this point, we are ready to move on to the other topics in lesson 1. And this shouldn't take as long as the fundamentals. Okay, so, but I would suggest paying close attention, because we're now getting into the specifics, and there'll be some practical things that you're going to want to take note of. Okay, so with that, let us proceed. So we're done with the fundamentals. Let's jump into the next topic under lesson 1, which is evidence gathering. Okay, so here let's start with a recall. Let's take a look at something that we discussed earlier in this module, namely when we were defining case buildup. Okay, recall when we defined it, we said that it was a process of building a case, right? And that this process involves 6 steps. Okay, so let's take a look at, again, just to review what those 6 steps are. Okay, so step 1, know the violation and essential facts. Step 2 is identify essential evidence. 3 is gather and preserve that evidence that you've identified in step 2. Step 4 then goes to the preparation of affidavits, complaints, and miscellaneous pleadings. And step 5 is where you would file that complaint along with the affidavit and pleadings. And then the last step is once you've filed your complaint with the attachments, the pleadings and affidavits, step 6 would be in monitoring that case, which necessarily involves assisting the prosecutor. Okay, so what we've said also when we were discussing what would be in lesson 1 and lesson 2 is where we would find the steps in relation to the topics for each of the 2 lessons. Steps 5 and 6, you might recall, we said would be found within lesson 2, those 2 topics in lesson 2. So that being said, why don't we remove them from this list that we have in front of us? Okay, and then step 1, we did say, and you might recall we actually did this, that all of those activities involved in step 1 we've actually been doing since the start of this course. We looked at 11 laws, and we did a number of things in those laws. Mainly, we looked at the prohibited acts and homed in on the specific provisions that define them to find the elements. Okay, and in doing that, we were able to determine what the violation is, and what from that violation would constitute the essential facts that would help us conclude that the evidence that the violation did occur. Okay, so since we've been doing that, why don't we go ahead and gray that out, and so we're not having to completely rediscuss it again. All right, gray that out, and at the same time, let's organize these 3 steps, steps 2 through 4, because these are the 3 steps that would form part of the remainder of lesson 1. These 3 steps would be found in the evidence gathering subtopic or topic, and in the pleadings and proceedings topic. So let's go ahead and just move those to the left, just keep them so they're organized and we have space on our screen to work. Okay, so since we're done with step 1, although we will revisit it shortly and just do a little bit of review, let's now focus on step 2 and step 3. Okay, in step 2 we said that we were gonna identify essential evidence, and in step 3 the activity involved gathering and preserving the evidence we've identified in step 2. All right, so we'll talk about step 4 later, but let's now focus first on step 2 and 3, and we're going to talk about them at the same time. All right, so in getting to the activities that are involved in step 2 and 3, there are actually 2 ways to get the answers that we seek for those 2 steps. Okay, the first involves looking at the things that we've done in step 1. Okay, remember in step 1 we were looking to determine what are the elements of the offense. Okay, so in our findings, the worksheets that came out of that activity, we should be able to determine, even at a high level, what the identities are of the, what the essential evidence, the essential pieces of evidence are that we would need. Okay, we would be able to identify from those worksheets. Okay, and that at the same time we should also be able to determine at a high level how we might gather and preserve the same. So addressing both steps 2 and 3. The second way that would help us answer exactly the questions that we seek, or answers to the questions that we seek on step 2 and 3, is if we look at a circumstance, let's say for example, you're given, you're not building the case from scratch. The case is actually being referred to you, so there's already some facts that are available. Okay, so the second way of identifying the essential evidence and determining how to gather and preserve such evidence would stem from that baseline, would stem from the facts that are initially given to you. Okay, so that would be the second way of coming up with those answers. So two ways, right? So let's get even more specific and let's look at the first way first. Okay, so before we jump into exactly how to do that on this first way, let's just do a quick review of our activities on step 1. Okay, you might remember we would look at the law, the subject law, whether it's the Forestry Code or any of the other 11 laws that we covered in modules 1 through 3, and focus on the areas that discusses the prohibited acts. And in those, we look at each one of the provisions, namely the provisions that define the crime or the offense. And from that definition, we try to identify the elements. So why don't we just quickly review that? I took from the Forestry Code a provision that we specifically looked at when we were discussing the Forestry Code. So this might seem familiar to you. All right, so I went and pulled up section 77. This is the provision entitled Cutting, Gathering, and or Collecting Timber or Other Forest Products Without License. This is the one that was medyo maraming word, it was wordy. And so there's a number of, within this same provision, there are a number of circumstances that make it so there's essentially 3 worksheets that we can prepare from this. And by the way, this is the same provision that we discussed earlier in the other topic while we were still in fundamentals of evidence. So anyway, focusing on this section, we could see, at least on what I have on the screen so far, we could see at least 2 of the circumstances that would give us 2 sets of elements. Okay, so let's identify them real quickly. So the first element, of course, looks to identifying who the offender might be, and from here we can see that it's any person. And then the second element that we are aiming to answer or to get answers for are essentially what was the act or omission committed, okay, or what was the act committed, okay. And here we could quickly ascertain that the act is cutting, gathering, collecting, removing timber or other forest products from any forest land, or timber from alienable, disposable public land or for private land. Okay, so that's the act, and we know that that may not necessarily by itself be unlawful or prohibited. So we look to see if there's any qualifier that would make it prohibited, and there is. You see the highlighted there, the highlighted part. That's without any authority. So you can see now on the right side of the screen, we have our worksheet that basically organizes those elements for us. So it gives us the quick reference. So let's see if we could, from the same section, identify or ascertain the second circumstance requiring its own worksheet. And we can. So first, we know that it also refers to any person who shall, and the act here is possess timber or other forest products. Okay, and it also has a qualifier that's highlighted there. Qualifier, of course, is that their means of possessing timber and other products is by way of, they possessed timber or other forest products without authority. Basically, they didn't have the legal documents that are required under laws. Okay, so there you have it on the right. We now have our second worksheet that essentially cover the second circumstance in this section. There's also a third circumstance you might recall that we discussed. Let's pull that up. Okay, and from here we could also quickly ascertain what the elements are. The offender would be officers of a partnership, association, or corporation, and their act would be of ordering the acts that we talked about on the first two circumstances. Okay, they ordered the cutting, the gathering, the collection, or possession. Okay, so it pertains to the two other circumstances. All right, so there we could also create a worksheet for it. So now we have 3 worksheets. So with these 3 worksheets, we can now proceed to look at the 2 activities in steps 2 and 3 and get answers for those steps. Okay. For these 2 steps, we created a table, a simple table, and as you'll see, the first column represents step 2, and in step 2, of course, our objective there is to identify what are the essential pieces of evidence, and then the right column represents the answers we are looking to gather from step 3. Step 3 is the step of gathering and preserving evidence that were identified on step 2. Okay, so there you have a simple table that we're going to be using. All right, so now as I said, this first way that we're looking at is a way to learn answers to these 2 questions based on these 2 steps, based on what is on the law, what the provisions of law says in terms of the I'm referring, of course, to the prohibited acts, the punishable acts under the law. All right. So since we have these 3 tables on top, or 3 worksheets that we've created on top, we could use that more or less as a baseline to determine how we're going to answer the question on step 2 and the question on step 3. Okay, and since we really don't have any actual facts and circumstance to base it on, we're just going to base it on the elements of offenses. All right, so we're going to base it on these 3 circumstances, these three worksheets that represent the different punishable acts under this provision of law. All right, so on the first step, step 2, the objective is to identify essential evidence. All right, so looking at the worksheets, we can see that we've broken them out into 3 different elements. The first element speaks about the offender, the second is on the act, and then of course the third is the qualifier. So based on that, we could quickly ascertain that the first essential evidence that we should aim for is the identity of the suspect or suspects, right? So clearly that would make sense for a lot of reasons. Okay, number 1, we need to know who we're going to go after, and it's that person's acts that determine whether he has violated it or not. It's also that person or persons who would be responsible for getting the necessary permits or licenses in order for them to do those acts lawfully. That without those licenses or permits, they would be proceeding to do those acts unlawfully. Right? So it's essential that we identify the suspect or suspects. So clearly that is one essential evidence that we need to identify. Right? Who are the suspects? The second thing, and again we're going to base it on the elements. Second thing, of course, is what are the particular activities that we're seeing that shows that they are committing those acts, right? Like for example, on the first worksheet, it's talking about an act of cutting, gathering, collecting, removing, forest products from any forest land, etc., etc. So we need to be able to identify, I mean, we don't know specifically what those would be yet because we don't have an actual circumstance, but the law does say that, the person, in order for them to be committing the offense, they have to be doing these acts, right? The act of cutting. So we need to be able to gather evidence of the commission of those acts, okay, as to what those those particular, activities are in the commission of. We don't know yet, but clearly we need to flag that as an essential evidence or source of evidence, a source of essential evidence, right? And then the last thing is basing on the third element, which is the qualifier. Naturally, an essential evidence would be, since all of these three circumstances tell us that the acts would be unlawful if they are not authorized. Those acts are not authorized by way of a permit or a license. So naturally, the essential evidence that we are identifying there is whether there is an invalid permit / authority, or there is none. Okay, because again, that's the determinant as to whether the act that was committed is unlawful or not. Okay, so in terms of how we're going to go about identifying or gathering and preserving what these essential pieces of evidence are, going back to the identity of the suspect, clearly an important source of that information would be accounts from witness accounts. So you'd want to be talking to different people who may be able to help you determine the identity of the suspect or suspects. Okay, and naturally, in order to preserve whatever they tell you, if it's of value, if there's a probative value in what they're telling you, the way to preserve that, of course, is to reduce it in writing, and not just not just reducing it in writing, but make it so it's a sworn affidavit. That it's that they're saying it. After they've sworn in that they've swore to tell the truth and nothing but the truth, so help them God, right? So it would, the preservation of the witness accounts would be by way of those sworn statements. Okay, so again, in terms of how to gather, it would be the witness testimony through and preserved through affidavits, sworn affidavits, and public records would also be a good source. As we've seen on this type of offense, we're not dealing with just individual persons. These, in many instances, involve large-scale operations. So there would be some kind of an association, either a partnership or a corporation, some kind of an organization involving multiple people. And clearly they would have some legal personality, that organization, and they'll need to know who the officers are, right? So in those cases, we do know that the Securities and Exchange Commission is the body that blesses, binibinyagan, kumbaga, juridical entities. Before they can be juridical persons, they have to go through the process through SEC, and SEC is the one that grants them that juridical, after a rigorous process, of course. So being that's the case, the SEC would be a great source of identifying those suspects. Okay, and they do, it's what they have is, they do have some data that's of public record. You can just go there and request it. Okay, so that's one way, or a couple of ways that you can gather identity of suspects. In terms of preservation, going back to the SEC, in terms of preservation, since it's public records, it's clearly an authoritative database. So in a way, it's self-preserving. It's self-preserved. In other words, I guess is what I'm trying to say. So what you really only need to do when you're ready to present such piece of evidence in court is that you need to get some authentic certification, okay, from SEC. Okay, so maybe a certified true copy of a piece of document that provides that information, or a separate certification, whatever whatever makes the most sense, whatever you're able to get, and whatever SEC allows. as long as it's something that's authoritative, that can be used by the courts as basis for authenticity. Okay. Moving forward, let's now look at the evidence of the commission of the acts. Same here. I think you could get a lot from witness accounts, the testimonies from witnesses. They can tell you a lot about what they're doing. But not limited to them. You could also do your own surveillance, and in doing so, you would essentially become a witness also, which means that whatever you're able to gather would need to be reduced to writing in a sworn affidavit. So you as the investigator would also need to execute such a document, which of course you at some point probably need to authenticate when in the hearing. Okay, so all right. In addition to that, there's also reports from other agencies as well as other sources. Okay, for example, an example of other sources would be like the media, right? As soon as they publish, and usually it's not just one outlet that publishes; it'll be multiple. So when they publish, especially if it's like printed, okay, they'll have a record of the printed publication. You can use that as basis. You could even get certification from them of the actual publication of that. So at least you're not just holding a piece of paper, but a newspaper that was certified by the publisher that it was indeed one that they published on a given date at a given period, something like that. Okay, so there you have it. A couple of sources of information or evidence of the commission of the acts. Okay, so those would be the things you could do to gather and preserve. And then of course on the last essential evidence, you could just go to the DNR. Since we're talking about environmental crimes, they would just have the various line bureaus, the pertinent line bureaus, depending on the subject matter, whether it's a violation of the forestry code, since they issue permits for cutting and whatnot, the particular bureau that deals with that would be the right entity to go to. Same goes for the other subject matter, for violations of brown laws and so forth. It will have particular line bureaus you can go to. In any case, they could provide the certification as to whether the person that you have identified, so clearly it's important that you identify that suspects, okay? In which case then the DNR would have the basis for determining if that identified suspect or sub-suspects have been issued permits or licenses, and if those licenses and permits are still valid, and specifically what they allow them. So at least you can compare if their license is for something but they're active for something else, then clearly that would still be a violation. So again, DNR could provide the specific details that you need to help you determine if that essential evidence is of value. Now we go to the second way of getting the answers that you would be seeking for the activities on step 2 and step 3. Okay, recall that in the first way, we said that the source of the essential evidence and how to gather and preserve such evidence, the source in that first way is the law itself. The the provisions of law that defines the crime, where we are able to also ascertain the elements, and those are essentially our basis for determining the answers to steps 1 and steps 2. So this second one that we're gonna look into is a little different. This is based on actual facts and circumstances, no matter how little they may be. So in these scenarios, these are when, for example, a case is referred to you. Perhaps there's already a complainant that filed with the department, with your organization. Let's say you're a environmental law enforcer. So your agency receives that complaint, and surely that complaint will have some details in there on the allegations of a wrongdoing, and so that would be given to you, and based on that you have something to go on to help you answer with greater well, not greater, but at least with some specificity as to, you know, who the suspects might be and what evidence might exist in the commission of the acts, as well as whether they have permits or licenses. Okay, so what I'm referring to are essentially, as I said, they could be cases that are referred to you, or probably the best example we could cite here is the assignment. I think I mentioned to you earlier that you either, I don't know if you received it yet or they're waiting to give it to you guys until after you've completed module 4. But anyway, there's an assignment that's going your way. There's in that assignment, there's actually 3 hypothetical cases, and those hypothetical cases are reports. You know, they're essentially a witness's account of something, and so based on the hypothetical case, you should be able to draw some answers. Okay, so let's go ahead and use that in demonstrating or illustrating how you would get answers to this second way. All right, so let's pull up one that you've already seen. In fact, you may already have this. I displayed this to you or showed this to you in an earlier presentation. This is the first of 3 hypothetical cases that form part of your assignment. This one, the hypothetical case, is entitled "Up in the Mountains Without a Clue." Okay, so let's just quickly read it so we can get a better idea of what it's about. Okay, a group of indigenous people, or IPs, were walking towards the forest area with their ancestral land, where they gather fruits, firewood, and other essential needs. Along the way, they heard a distant sound of running machines, followed by the sound of trees crashing down and plants being crushed. Curious and concerned, they moved towards the noise, and as they drew closer, they saw people using chainsaws to cut down century-old trees. Trucks and bulldozers crushing new plants within their cherished ancestral domain. Okay, helpless, they watched silently as the trees continued to fall and their forests destroyed. Feeling the urge to do something, the group of IPs rushed down the mountain to the barangay chairperson, whom they trusted even if he was not one of them, to tell him what they saw. They all sat down together to think. They knew what was happening was wrong, but they knew that some officials were part of it. So they decided to go directly to the prosecutor and the courts instead. Okay, so from these 2 paragraphs, you could already quickly identify some possible violations of law. Okay, but for this demonstration that we're gonna do, we're gonna home in on one particular phrase or sentence. Okay, and that's this one. This one speaks of people using chainsaws to cut down century-old trees. So based on what I've highlighted there, we're able to determine what kind of law may have been violated. Okay. Now, on your assignment, you will be given a worksheet, another worksheet, a third one, right? So you already know the first 2 that we've been working on. Well, the first one is something that we've been working on from module 1 up until present. The second one, I just introduced it just a few minutes ago, to identify essential evidence and to determine how to gather and preserve. Okay. This third one is actually, as I said, part of your assignment. And in fact, this is something you could use if and when you decide to take the plunge and become an environmental investigator, environmental law enforcer who is tasked with investigating violations of environmental laws, this may come useful. At the very least, it can give you a baseline from which you can create your own methods of investigating. Okay, so anyway, this is the worksheet that I'm talking about, and this is part of your assignment, which if you haven't already received, you should be receiving sometime soon. Okay, all right, so here it is. It's a table with 5 columns, and each column represents questions that you need to answer. Excuse me. Each row would be as many answers as you can identify based on the circumstance in the hypothetical case. All right. So for our demonstration now, we're only going to home in on that phrase that I've highlighted. They saw people using chainsaws to cut down century-old trees. So that phrase immediately tells me that the answer to question number 1 would be that it may be a violation of the Chainsaw Act, right? You recall we talked about that when we were talking about the green laws. So sure enough, I pulled up the law. So I'm going to go ahead and put it in there as an answer to this first case that I'm seeing on this hypothetical case. And in looking at that law, I sought answers to question number 2, which is what is the specific section in that law that contains the offense that I'm sort of clued into from this hypothetical case. Okay, and I find under section 7, subparagraph 4. Okay, and now we proceed on to question number 3, which will give me the specifics. Will give us the specifics on what's on section 7, subparagraph 4. Okay, it says that in that scenario, it's the prohibited act is any person who is found to be in possession of a chainsaw and uses the same to cut trees and timber in forest land or elsewhere. And the qualifier, of course, is that if they are authorized by DNR. Okay, so the general rule is they are not, if they're found to be in possession of chainsaw and uses the same to cut trees and timber in forest land or elsewhere. Okay, general rule is they are committing a prohibited act. The exception is if DNR authorizes them, and of course that means a permit or some license or something of that sort. Okay, so anyway, as we can see from the highlighted phrase or sentence in the hypothetical case, it says they saw people using chainsaws to cut down century-old trees. So using and cut down, okay, those are the 2 keywords for me to tell me that they are in violation of this specific provision, because in this provision the actus was found to be in possession, okay, of chainsaw and uses the same. So they're using it to cut down trees. Okay, so in other words, it complies. So the question there is that I'd have to find an answer to is whether they were given an authorization, a permit or license or something by the DNR. Okay, and essentially that's where question 5 come into play. Okay, because that's where I would put in what I would do to get those answers, right? Because this is actually question number 5 is the same thing that is asked in steps 2 and 3. That second worksheet that we came up with, very simple worksheet that we came up with that we just worked on earlier, or a couple minutes ago. So that's what question number 5 is. Question number 3, going back to that, okay, uses the first worksheet that we've been using since module 1. Okay, so you see kind of how it all comes together, right? So question number 4, that's self-explanatory. This is just for tracking. If you decide to use this worksheet in your endeavors, then it's a good way to kind of at least have some citations or a means to identify your sources for particular pieces of information. So this one is just asking for what is your clue? Where did you find it? And it's clear that the basis for this is the hypothetical case. So the question there is what line item in that hypothetical case. And as you've seen, the hypothetical case is in a pleading-like form. So there's each line is numbered. So you can easily make reference to a line where you would find a particular clue. So that's exactly what we did here. Okay, so I hope that makes sense. And in any case, this should give you some instructions on how to proceed with your assignment. If you haven't already started it, this should give you an idea. So I gave you a giveaway, really. But do note, in reading this hypothetical case, this up in the mountains without a clue, I'm sure you're finding more than that what we just discussed. I'm sure there's a few more that you'll find there where you could fill in additional rows in this worksheet, okay? Answering it similarly, okay? So I think that should provide us a good idea of these two steps, step 2 and step 3. So we are now, I think, just about ready to move on to the last step on lesson 1. Pleadings and proceedings. So we shall now tackle this topic. A quick note, this actually should be titled a little differently. It should really be proceedings and instruments, therefore, okay? The instruments that are used in these proceedings, okay? Rather than pleadings and proceedings. And it'll make sense in a little while, but as to why proceedings should proceed, it's because we're talking about the instruments that you would be preparing. I mean, that's the intent of this topic, is to talk about the instruments that you as an investigator would be preparing to either commence an administrative case or institute a criminal action, okay? And in order to get a sense of how that all kind of comes together, how it gets to that point, and what happens after that point, it would be a good idea to talk about the flow, the entire proceedings, okay? The entire proceeding, and at a high level, of course, just so it's not too daunting of a discussion. All right, so proceedings and instruments, therefore. All right, so and this, as I said, would focus on the preparation of those instruments, and thus it would cover step 4 out of our 6-step process. So moving forward, let's take a look at the proceedings. We'll start with, as our baseline proceeding, we'll start with administrative cases. Okay, in administrative cases, we would build starting with starting with step 1 through step 3. Okay, step 1 being the first step of getting to know the violation and the essential facts. And then we proceed on to step 2, which involves identifying the essential evidence. Step 3 then comes after, which is to gather and preserve the evidence that you've identified in step 2. So now, step 4, you should be at a point where you have the evidence that you need and you're ready to take that step of preparing the instruments. Okay? So, step 4. And the primary instrument that you would be preparing is a complaint. Okay, that is the instrument that commences the administrative case. Okay, so as we said, before you get to that point, you need to build enough, you should have enough building blocks to a point where you've reached that quantum approved for administrative cases, which, as we said, is prima facie evidence. Okay, that is the foundational. I used the phrase foundational. That's kind of, if you might recall in the last couple of topics, I referred to that as the foundation of the case to commence the administrative case. So the foundational or the foundation to this administrative case is that you have ample evidence to get to this point where you're actually ready to proceed. And that quantum, when I say ample evidence, the extent of evidence is that you have prima facie evidence. And just to recap, we also discussed this, you might recall, prima facie is evidence that is good and sufficient on its face, okay, such that it is accepted as correct until it is proven otherwise, okay? So anyway, when you're at that point, you're now ready to proceed with the preparation of the instrument, starting with the complaint. And in administrative cases, the forms may look a little different depending on the quasi-judicial body that you're submitting to, and the particular subject matter, right? Whether it's a violation of green, brown, or blue laws. They may differ slightly, but for the most part, they will contain the same essential elements. Okay, so what I have here is one that I got from the Mines and Geosciences Bureau of DNR. So I'm not sure if you're able to see it completely, but it's just a form. Its essential elements are, number one, what the complaint is. The complaint should focus on is the ultimate facts, right? You remember that discussion between ultimate facts and supporting facts. The ultimate fact really is the ultimate proposition that you're making, okay? And that is that this person committed this offense as defined in section such and such of such and such environmental law, okay? He did this because he did that and this and that, and is therefore in violation of that law. So that's kind of what an ultimate fact should propose or assert, right? And in providing that ultimate fact, it should excuse me, it should provide the 5 wives and 1 husband. Okay, if you're not familiar with those 5 wives and 1 husband, okay, what we're referring to are the 5 W's and 1 H. Answers to the 5 W's and 1 H. The 5 W's being the who, what, why, where, and when. Okay, so who did this, who allegedly did this offense, and what exactly did he do, when did he do it, where, and motive usually, which is why, right? The 1H is how. Okay, so anyhow, those are the basic questions that should be answered when making that proposition. Okay, when you're making that ultimate proposition on that ultimate fact. Okay, so as I said, the complaints may differ slightly, but in terms of how the form looks, how it might be organized, but it should provide for the ultimate facts, and the ultimate fact should answer those 5 wives and 1 husband. Okay, so in addition to the complaint that is prepared, there usually is attachments. There usually are attachments, and those attachments are generally affidavits, witness testimonies. Okay, usually there's when there's an allegation, somebody's making that allegation. It could be you as the person that did the investigation. You have to testify about exactly what you did, how you concluded the way you did, and so you would in probably a number of instances you would need to prepare an affidavit of exactly what you did and how you concluded the way you did. Okay, so the affidavit, here's an example. This one is usually, this example is based on an affidavit of a witness. And this one, of course you can see it's in Tagalog, is in a format where it's just making a narration. It's, the witness is introducing his or himself, him or herself, and then talks about exactly what he or she is testifying to. Just makes a narration. Okay. And there are, in many cases, especially in criminal cases, the affidavits are more of a Q&A format, question and answer. Okay, so there's usually like either the investigator or maybe the prosecutor that will ask a question, and then the witness would answer it. Just simple as that. But this one is a little different. It's just making a narration. Okay. All right. So that's what an affidavit is. It's a sworn, or what a sworn affidavit is. Sinumpaang salaysay. Okay. All right. So with these two, that and of course, if you have additional evidence, you would include it on here, and that gives you essentially the instruments that you need to commence the administrative case. So when you have that complete, you would be submitting it to the quasi-judicial body, and the quantum that the quasi-judicial body needs to reach is substantial evidence. They need to reach that in order to conclude that indeed the person that's being alleged of having committed this violation did indeed commit it. And their basis, of course, is evidence that is substantial. Okay, substantial enough. All right. And when we're talking about substantial evidence, you might remember in our definition of that earlier, we said that it means what substantial evidence is such relevant evidence that a reasonable mind might accept as adequate to support a conclusion. Okay. So it's a relatively low standard, as we said before, but definitely higher than prima facie evidence. So there is still that need to, you have prima facie evidence to commence the action, but in order for the administrative action to conclude in favor of the state against the suspect or against the violator, the alleged violator, substantial evidence must be there to prove that. Okay, so let's see what else. Okay, we're done with administrative cases. You now have a general idea of the flow and the instruments needed to commence the administrative action. Let us now jump to criminal cases, and we'll present it similarly. In criminal cases, in the same way we would build a case, following steps 1, 2, 3. Okay, and when you get to a point where you have ample evidence, you would prepare the complaint. Okay, and you have ample evidence when you have reached that foundational quantum of probable cause. Okay, this is also relatively low standard, because the assertion is really that of probability or likelihood that this person actually committed the alleged offense. Okay, and the basis, of course, is a well-founded belief from the facts and circumstances of such probability. Okay, so it's a relatively low, and this is the foundational quantum that must be reached before the investigator, you as the investigator in a criminal environmental case, would need before you could institute the criminal action. Okay, let's now say that you have reached that quantum and you're ready to proceed. The instruments that you would be using similarly would be a complaint, okay, and affidavits. Usually the complaint and the affidavit are in the same form. Thus it's called the complaint affidavit. And same thing as the instruments used in administrative cases. it asserts the ultimate fact, and in doing so answers the questions about the 5 wives and 1 husband, right? Okay, so the complete affidavit, this is an example one. In criminal cases, they're fairly consistent in the way they look, right? Fairly consistent in the way they look. So let's go quickly over this one I have on the screen. Notice that, as I said earlier, it's in a Q&A format. There's a question and then the witness makes an answer. Okay, let's just scroll through the entire sample that we have here. All right, so there may be need to provide additional affidavits. So same thing, same example that I cited in the administrative cases. Okay, now to reach probable cause, generally it's documentary evidence, these evidence that we showed, including the complaint of course, that is submitted. But since there's a higher standard in criminal cases, there would naturally be need for additional pieces of evidence. It could be object or additional documentary evidence. Generally, documentary evidence is what you would submit, but you may need the additional evidence to support the instruments that you're submitting to institute the criminal action. In those cases, the rule provides that you just make those available. They're not necessary in the submission, but you just make those available such that if there's a need to reference those, that you can make them available for that purpose in order that the process could step forward. Okay. So anyway, these materials, these instruments to institute the criminal action would be submitted to the prosecutor, okay? And the prosecutor, at a high level, really what he does is makes a determination of whether it's worthwhile to proceed or not, to proceed to file the case in court or not. And basically that step that he or she takes, the prosecutor, would be determining if there's ample evidence. And ample evidence here is that that the complaint has reached that foundational quantum of probable cause. So essentially he just verifies that indeed what you as the investigator have compiled does indeed constitute probable cause. Okay. Now, depending on the extent of punishment, then what he or she does, what the prosecutor does, will differ slightly. For example, if the punishment for the alleged offense is more than 4 years, 2 months, and 1 day, then the process for determining probable cause is more formal. It employs what they call the preliminary investigation. Okay, it's a quasi-judicial function, okay, where the prosecutor is impartial, doesn't know the facts, doesn't know the details, doesn't know the parties. They cannot be biased. They must not know those things. So, and then all of these instruments are provided to the prosecutor, serving as the preliminary investigator, the quasi-judicial function of adjudicating whether there is indeed probable cause or not. Okay, so it takes a look at everything that is submitted to him or her and makes such determination. And again, this is a formal process, and it also may require, actually, as part of the formal process, that the accused is given an opportunity to make counter affidavits, counter assertions, and that may go back and forth between the prosecutor and the accused. Of course, it starts with these instruments. These instruments are the allegation to start the process, and then the prosecutor would give the accused an opportunity to provide counter affidavits, and then it goes back to the prosecutor to, or not the same prosecutor that's doing the preliminary investigation, but um, who would essentially the person that's making the allegation. That may involve, of course, you as the investigator. You would, you may need to do a counter to the counter affidavit, and it goes back and forth a few times. Okay, so what the prosecutor, of course, the PI prosecutor is aiming for is to have all that he or she needs to make that determination. Okay, and so assuming that he or she is able to reach that quantum, okay, then he would be in a position to make that conclusion. He makes that conclusion through a resolution, and then either he or another prosecutor would be the one to proceed to file this in court, and that process is called indictment. And what he or she would use as an instrument is called an information. Okay, and that's essentially the complaint, but just transposed or converted into slightly different format. But it also has the most ultimate facts and answers the 5 W's. One was in this information, and then that's what's used to start the indictment. Okay, and that is submitted with the court. And of course, as we know in criminal cases, what the court needs to conclude that this crime indeed was committed, and that person that was alleged therefore actually did it. The quantum that's needed is proof beyond reasonable doubt, moral certainty. The judge has reached moral certainty that he or she is sure that if he judged guilty, that indeed morally he's morally certain, he or she is morally certain that the person actually did it. Okay, so that's the process in criminal cases, and those are the instruments. Okay, an important point of mention is there's a big disparity between the foundational quantum of probable cause and the quantum for proving the case. Okay, there's a huge disparity. Okay, proof beyond reasonable doubt is the highest quantum, the most difficult to prove. Okay, because you're trying to get the judge to reach this moral certainty. Okay, and probable cause, like we said, is only probability or likelihood, and it's just based on well-founded belief. You have, in order to reach the proof beyond reasonable doubt quantum, there has to be actual, additional evidence, strong evidence, probative evidence with ample probative weight to reach that moral certainty. Okay, so there's that big gap. So there's an issue there, because when the prosecutor makes the determination of probable cause, many times, what he has is really all that you submit to him or her, which are the pieces of evidence to reach probable cause. So in order for him or her to be effective at proving beyond reasonable doubt in court, he would need additional evidence. And in a lot of cases, they don't go back to the investigator, or even themselves don't conduct additional case buildup to reach that point. So they just submit it as is and hope that the evidence for probable cause would be sufficient to also prove beyond reasonable doubt. Unfortunately, that only works about 14 to 20% of the time. Okay, and that's the reason why the conviction rate, in general, not just in environmental cases, but in general, in the Philippines in the last decade or so, conviction rate has only been 14 to 20%. Okay, so there you have it. This gives you a summary of the proceedings and the instruments, not only in administrative cases, but also in criminal cases. Now, since we use the word pleadings, let's just quickly differentiate it from the instruments that we're talking about. Proceedings really are, where's my slide for that? Okay, pleadings are written statements of the respective claims and defenses of the parties submitted to the court for appropriate judgment. So essentially, pleadings are instruments, and they are the instruments that are submitted to the court. Okay, and essentially, the complaint, if you think about it, is a form of pleading. Except in your case, as an investigator, you're not submitting it to the court; you're submitting it to the prosecutor. So it's not pleading in the way pleadings are defined in legal proceedings. Okay, they use the word pleadings a lot in civil cases, but you won't be dealing too much with those. But I think the most important point here is pleadings are the formal pleadings are not something that you, as an investigator, would be involved in. Okay? The extent of your involvement is really on the complaint and gathering the attachments therefore. The pleadings themselves, in the way it's defined in legal proceedings, are prepared usually by the lawyers, the prosecutors in criminal cases, and perhaps even the defense on other cases, especially in civil cases, since they would be submitting pleadings also in answer to provide their defenses for their clients. All right. So I guess the point I'm making is you would probably not be involved in them. You may provide some assistance, but because of who actually prepares them, which would be the prosecutors, you would not very likely not be involved in them at all, other than just provide some assistance. Okay, so there you have it. That should give you a general idea of this whole topic in terms of the proceedings, the flow therefore, and the instruments that you use in those two cases. In administrative cases, the instruments that you would need to commence the administrative action, and in criminal cases, the instruments that you would need to institute the criminal case. Okay? And at this point, we are essentially done with lesson 1, and we're going to jump now to lesson 2. And this should be a fairly quick process, much the same way we just breezed through lesson 1, the last part of lesson 1, where we talked about pleadings and proceedings. The two topics in lesson 2 would go in similar fashion. It would probably be just as quick, if not quicker. Okay.